Hey guys, good morning. Good morning, good morning, good morning, good morning whenever you come in. Hi guys. So I was just on a live on my other channel and I got off and I noticed that Stephan Sterns had court today. If you remember last month his court date was canceled and lo and behold there was court today. So let's get into it. They had a pretty lengthy hearing. His CP cases are coming up very soon. So let's get into it. Let's see what happened because I missed the whole thing. So also I talked to you guys about a case out of California yesterday. Um, the guy's name is David Brinson. He actually is already doing a couple of life sentences and he had a conjugal visit with his wife and ma'am was found strangled to she was found unresponsive and it was ruled a homicide a couple of days ago. So I called the county yesterday because you couldn't get the paperwork online. You had to call. So I called yesterday. They got me my police report and at 12 o'clock I need to pay for it over the phone and then they'll email it to me. And sis was like, it's 30 pages. I was like, oh my God, oh my gravy. So at I'll be listening, but in about 20 minutes I need to get that document so we can talk about that other case also out of California. It was just ruled a homicide. And the prosecutor has filed charges on him for the death of his wife. Anyway, who is Madeline Soto? Madeline Soto is a young lady who was taken out. Um, and her mother's boyfriend, mom allowed her boyfriend to have certain privileges with her daughter, and the daughter is no longer with us. She was found unalive a few days after uh it was obvious that she hadn't reported to school. And yeah. So I think I have a playlist. I have a playlist for those videos. It's pretty gruesome. He has this case right now is the CP charges, of which it's voluminous. And then in September or October, I think, I don't have the dates in front of me because I just got off my live stream. His other case is set to start for, but yeah, Madeline had literally just turned 13 and mom was asleep on the job and mom's boyfriend is on trial. So, um, like I said, I do have a playlist. So there's a lot of information. Regarding this topic, but yeah, it's but anyway, let's get into it. So you'll be able to hear a lot because this is the first time he's actually been in court. Um he's been not wanting to show up for court, and today he is in court. And I think they actually summoned that he must sit in court because this is a very serious trial and you can't just call in sick. Like you have to be here. So that's what's going on right now. Let's go ahead and get into it. I might stop periodically, but we'll talk about it definitely when it's over. But I want to hear with you guys what happens. So let's get into it. The sound is out for the first
Your
couple of
client's
minutes.
been
Here it is.
formally recognized as interveners in this party.
We have made our appearance, but I would like to go ahead and formally do that now to the extent that permissible to the court.
All right, thanks. And pursuant to civil rules of procedure, intervening is somewhat commonplace pursuant to Civil Rule 1.230. In criminal cases, it's somewhat unusual or less common, almost always more restrictive, and requires leave of court to be permitted to be an intervener and make argument with respect to the defense request. I believe that's going to require an evidentiary hearing. The interveners would have to make a determination as to whether their request is timely, the nature of the intent behind their intervention, the whether the court would need to make determinations as to whether that would unduly complicate the case or prejudice the proceedings, and that has not been requested at this point.
Sir, it is my understanding pursuant to the Lewis case, 1982, Supreme Court case, that we receive essentially automatic intervention for the purpose of opposing closure hearings. If I could refer Your Honor to that case, specifically case number 426 Southern 2nd at 1. Media interveners on behalf of as a proxy of the people of the state of Florida for the purpose of intervening, essentially receive automatic the ability to oppose essentially just by walking in. That's been the rule in Florida since 1982, and I do refer Your Honor to that case.
Wasn't the media a party in that case?
No, sir. They're interveners, as they typically are. Typically, the way this works is the criminal defendant will seek closure, whether over a specific record or over a particular hearing, such as a suppression hearing, and then by law, there has to be a notice to local media, at which point the media then intervenes and receives the right to, at any suppression hearing or any hearing pursuant to that, the right to argue at that suppression hearing or any hearing related to closure. And so that's been the policy of the state of Florida since 1982.
All right. So it's your position that the court has no discretion whatsoever to make a determination as to whether intervention is appropriate?
I have never been in a position, I've never had a court even raise that issue. So I do not know the particulars of that issue, Your Honor, because typically it just happens pursuant to Lewis. And so it is the media intervener's position that pursuant to that case and all the cases that have been pursuant to that the media has an immediate right to intervene.
Was it your intention to make argument?
Yes, sir.
All right. Thanks. All right. Well, you're gonna have to provide me a copy of that case and indicate that the court is without discretion to allow argument as a non-party in a criminal case. You have a copy of that case for the court?
I do. Yes. It's been couched in the context of standing to intervene.
Indeed. You have standing to intervene. This is the Miami Herald case v. Lewis?
Yes, sir.
Yeah, I agree that you have standing to intervene if the court issues an order. I've not been provided with any authority that gives automatic entitlement to intervene in the defense's motion requesting an order from the court. I think the requirement of the rule indicates that you must have notice, and from your pleading, I'm going to make the assumption that the media had notice of today's request. Is that correct?
Yes, we were provided notice, which is why we filed the notice, the motion, the intervention approximately 2 weeks ago, Your Honor, on the docket.
Understood. In Miami Herald Publishing Company v. Lewis, 426 Southern 2nd 1, a 1982 Supreme Court case. In that case, the court ruled that the media had standing to challenge a ruling from the court after the ruling was made. Was there any indication that there was an automatic entitlement to intervene in the initial hearing making that determination?
I believe so. It's either in that or there was other subsequent cases in the late 80s, Barron and others, that said that there has to be notice to local media, at which point the media intervenes by filing a notice of intervention and receives the right to argue at any pursuant hearing.
All right. You've referenced that precedent. Do you have case law that supports that you can provide?
I do not in front of me, Your Honor. This is a matter I must confess that I have never encountered in arguing these before.
Thank you. I'm going to entertain argument by the parties in the case, and then I will consider your position. Perhaps you can secure some case law that creates an automatic entitlement for the interveners to argue in the initial.
Okay, let me say something really quick. So I was trying to figure out, okay, what's going on? So this is the, can y'all see? All right. This is the, look how many CSAM. Okay. Look at all this. Okay. Look at all these charges. Baby, it's a mess. Okay. The on 310, the media, so the media's interveners opposition to defendant's motion for closure of all pretrial proceedings. So apparently there must have been a motion filed. So motion hearing 320 at 9:30, closure. Okay. So this motion was filed right here. I guess to kick the media out. I mean, of course, it's like the standard thing now. Everybody wants a damn gag order. Motion for closure of all pretrial proceedings. So apparently the media at large got together with one attorney to basically advocate for, I'm assuming, the open court. Okay. It says, come now, the defendant Stephan Sterns bind through the undersigned counsel. Can you guys see this one that I'm showing? Yes. Okay. Let's see. Is this the right one? Yes. Okay. Comes now the defendant Stephan Sterns bind through the undersigned counsel pursuant to 5th, 6th, 8th, and 14th Amendment of the United States Constitution. Article 1, 2, 9, 16, 17 of the Florida Constitution moves this court to enter the order closing all pretrial proceedings in the cause to press and public. So they don't want us to know shit. Okay. They want to kick us out the courtroom that we pay for because he probably is feeling some type of way about people knowing about the creepy stuff he had going on. Mr. Sterns is charged with multiple counts of sexual battery on a child under 12, sexual battery with a child from 12 to 18, familial custodial authority, lewd and lascivious, molestation, unlawful possession of material depicting sexual performance by a minor, I'm gonna say it like that, and images. This case has been subject to unprecedented and highly prejudicial publicity and media attention in Osceola County, adjacent areas of Osceola County, a majority of the state of Florida, outside the state of Florida, and even internationally. At every court proceeding, however minor and inconsequential, there has been extensive coverage by the press as well as social media users of YouTube, TikTok, Twitter, and Facebook. It is anticipated that the press will continue to be active and aggressive in the coverage of all events and proceedings. I mean, it's just like, welcome to 2025. I mean, the media, people want to know what's going on. The counsel for Mr. Sterns intends to pursue numerous pretrial motions of evidentiary and legal significance in the preservation of Mr. Sterns' rights for a fair trial. The type of motions Mr. Sterns expects to pursue include, but are not limited to, motions to suppress, motions to exclude evidence, motions in limine of irrelevant and prejudicial testimony and evidence, and other motions which could include a motion for a change of venue if the media coverage of this case continues as it has, so Mr. Sterns cannot receive a fair trial in Osceola County and most of the state of Florida. Counsel for Mr. Sterns has already filed 3 motions. I would say he shouldn't have been messing with that lady's child. How about that? Counsel for Mr. Sterns has already filed 3 motions to suppress, which various media users have read, dissected, and commented on extensively. Counsel for Mr. Sterns has already filed 3 motions to suppress, which various media users have read, dissected, and commented on extensively, because that's what we do on social media. These motions will require testimony and discussion of evidence in this case prior to the trial. In some instances, in these discussions of Mr. Stearns, I mean, look, guys, we came into this live. Somebody immediately asked, they didn't even know what was going on. So it is not saturated. Just because you live in the state of Florida, everybody doesn't know about Madeline Stearns, Madeline Soto. Everybody doesn't know Stephan Sterns. Okay. And then, so yeah, so we see where this motion is going. Miss Melissa Vickers basically is, I mean, this is standard now. I mean, how many cases do we follow and they're filing something to say that it is impossible for their particular person to get a fair trial? Okay. Like, so this is pretty standard now, right? We've seen this a lot. These motions will require testimony. Okay, I read that. In some instances, this could involve evidence that may later be found to be inadmissible, including in these discussions. Mr. Stearns' evidence will be Mr. Stearns' statements to the police, medical examiner's findings, potentially discussions and evidence related to the statements from minor children. Public dissemination of these items of evidence will prevent. It's already out here. Let me tell you, Kasemi, I have an 800 page document. I think it's in my Patreon. But if you're in my Patreon, there's probably 15 interviews that the police conducted along with body cam. Kissimmee Police Department has given out the whole entire jacket. They've given out everything. I mean, not everything, but they've given out a lot of information. So it's too late for that. It's too late. It's way too late. These motions. So anyway, included in these discussions, Mr. Stearns' evidence will be Mr. Stearns' statements to the police, medical examiners, and potential discussions on evidence related to statements from minor children. Public dissemination of these items and evidence will prevent Mr. Stearns from receiving a fair trial. Public discussions in the press in the form of news stories, polls, letters to editors and editorials will lead to an environment which will preclude Mr. Stearns from being afforded a fair trial in Osceola County and most of the state of Florida. Counsel for Mr. Stearns feels there is no suitable alternative measure to protect Mr. Stearns' right to fair trial under the United States and Florida Constitution other than closure of all pre-trial hearings. Can you believe that? So this is what they're talking about today. So if anybody was wondering what is going on today, what are they talking about? What is at issue? This is what is at issue. And let's go back and resume where we left off. Okay. Okay. Hopefully that helps, because I was kind of like, okay, what's going on? Okay. And then that being said, so that was the motion that was filed by Mr. Stearns' lawyer. And then there was a motion filed, non-parties and interveners, WFTV, WKMG, Fox 35 Orlando, WESH TV, and the Orlando Sentinel respectfully move to intervene in this case for a limited purpose of opposing the defendant's motion for closure of pretrial proceedings filed February 18th. So they have come together as the local media in the area so we'll see what this particular motion states. If it's necessary, I'll read it, but I'll post it for you guys if you want to read it. But let's get back to this. It's just getting started. The lawyer who was standing up basically was representing for the media, this guy right here. And so we're going to get into the motion. Okay.
Determination by the court as to closing court proceedings. So, may I have a seat? Thank you. Sir. And State, do you have a position on a non-party intervention
No.
Defense?
See who the lawyer was? Did y'all see who that was? Any of my Sarah Boone
No.
people? Girl, that's Mr. Cacciatore. Excuse me, that's Mr. J. That's
A
Mr.
non-party intervention?
Hold on.
No.
That's Mr. J from the Sarah Boone trial, baby. This is going to be good. Okay, because this is the 9th District of Florida. So 9th District of Florida is Osceola and Orange County. Sarah Boone was Orange County. This is Osceola, but it's the 9th District. Okay, baby. Mr. J don't play. Okay. Ooh, this is going to be good. I didn't know he was assigned to this case. Okay. I'm
Defense?
here for it.
I will leave it for a second. Generally speaking, I guess we have an objection, hence the motion that we're
Notice how Stephan Sterns got a female lawyer.
following to ask for them to be precluded in terms of their intervention defense fits in the notice of hearing to various media outlets, so they were aware.
Thank you. This case was initiated by information on April 11th, 2024, charging Mr. Sterns with 8 counts of sexual battery on a child under the age of 12, capital offenses, 5 counts of sexual battery with a child 12 to 18 in a familial or custodial authority, 7 counts of lewd or lascivious molestation, 40 counts unlawful possession of materials depicting sexual performance by a child, 10 or more images. Counts 1 through 8 are capital offenses. Counts 9 through 13 are punishable by life offenses. Counts 14 through 20 are punishable by life offenses. Counts 20 through 60 are second-degree felony allegations punishable by up to 15 years in prison each, 15 years of supervised probation each, or a $10,000 fine each. Appears at the Miami Herald Publishing Company v. Lewis, 426 Southern 2nd, 1, a 1982 Florida Supreme Court case. Is the seminal case that discusses requests for closure. The defense has the obligation of proving to the court by a preponderance, meaning a greater weight of the evidence, the necessity for closure. Counsel, do you intend to present argument with respect to your motion?
Yes, Judge. Defense has had pre-marked several defense exhibits. I've given copies to the state as well as to the media, attorney for the media. Defense Exhibit A is a USB flash drive with a PowerPoint that's been previously signed by the state. Defense Exhibit B is a list of articles and videos. Defense Composite Exhibit C is the printout of various news articles. Defense Composite Exhibit D are emails with public records requests. And then I have case law as well, which wasn't pre-marked. I can just work now if the court would like that as well. And previously given to the state and the media attorneys.
Thank you.
They've been pre-marked. If we can, defense would at this time move each of those pre-marked exhibits into evidence as defense's next number exhibit 1 through 4, I believe they'll be.
Thanks. Consider these unopposed.
We'll waive any objections.
Thank you.
And if you could have the Elmo turned on.
Thank you. Do you intend to publish what's going to be defense 1?
Yes, Judge.
pre-marked exhibits will be received as evidence for purposes of this hearing only. I believe the overhead projector is on. We need to got the AV controls at defense counsel table. And HDMI.
Yes.
HDMI is plugged in and it's recognizing that it's plugged in, but it's not showing it.
Please call the AV department on.
While we do that, I can make additional present additional information at this time, Judge. In terms of the items that were pre-marked, defenses exhibit, if I could approach the correct have the correct numbers. Defense has printed and presented for the court, not that the court needs to read them all, but just showing the various media coverage of this case, various articles from local news stations, as well as court TV, crime TV, various news media organizations. Defense has also introduced a listing essentially of those articles that were printed, some of which have YouTube links, which obviously can't be printed for the court. Defense did do a public records request to show the court the public records requests that have been made by various media and interested parties in terms of this case, requesting public records for this case. And though we're not here on Mr. Sterns' other case, I printed the public records request as to each of those in comparison to another homicide that's in Orange County, which involved the death of multiple individuals, to show the court the comparative nature of the public records request and the nature of those items and information that was introduced as the fifth exhibit. I believe it's number 3. And I can provide these. I can give them to the court. And looking at, and the other ones are Madam Clerk has. And looking at those items that were introduced specifically as to the public records request, the court can see that in terms of Mr. Sterns' 2 individual cases, in doing the public records request, we had to pay an invoice of $56.25 to get just a copy, the printout initially of what was requested by various parties. So in that, the court will see that there have been various news articles or news outlets requesting information, and the court can even see within those some of the costs that were associated with them requesting and receiving the items that were requested and ultimately turned over. And in comparison, the case that defense printed additionally was a Chevelle case out of Orange County, which involved the injury and or death of 6 individuals. I believe it's 4 that were deceased and injury to others. And in that case, the state is also seeking the death penalty in that case. The PowerPoint that defense presented or prepared, and if we don't get aviation, if the court is willing to consider it in chambers, essentially just shows podcast interviews, TikTok, Instagram, Facebook groups, Reddit, and on those Reddit platforms shows essentially the full discovery in this case. You can see links to where the media and various parties have requested all the information, including their screenshots that show this actual hearing being presented on there, links to it, notice of the hearing in terms of this very hearing that we're here for today. There's also, as the court can see, and I would ask the court to make clear for the record that there are also media cameras and media personnel that are present today for the purpose of this hearing. So that will be the information defense will be presenting. If the court wants me to do argument at this time as well, I can do that as well, minus the aviation aspect.
All right. State, do you anticipate presenting any evidence in opposition of the defense motion or taking any position?
We will take a position, but we just have argument.
Thank you. Ms. Smith, I'm willing to wait until AV gets here if you have a presentation that you wish to present to the court prior to making argument. I don't know why your council table is not registering with our equipment. One suggestion I may have is if the state would be so inclined to allow you to look into their council table, see if that alleviates the issue.
We have an extra computer in the today.
That the HDMI cable on that table works.
I'm sorry, but I just don't think that there's anywhere that Stephan Sterns, if people know about the case, they know about the case. She's trying to make the point that there's other cases that haven't had as much media coverage as others, and that's just the way it goes. Everyone's not going to cover every case, but people are particularly disgusted by cases that include children. Also, the mother aspect was quite strange. There's just some nuances to this case that make, I mean, every single case that includes a child is not going to be viral, unfortunately, but it's the awareness that maybe one case that brings that can save 10 kids' lives, because you've got parents now and relatives and neighbors who are more vigilant because they've heard of the case. So every case, unfortunately, cannot be bubbled up, but I'm sure the people that are directly affected by that case, they know what's going on. Okay. But every case is not going to go viral. Okay. But nonetheless, a case being discussed and providing awareness gives people, it helps the community. It just does. It helps the community. It's not to give the less justice for the individual, but the individual has to understand the reason why they're there. This man sat up here and lied for damn 36 hours while the girl didn't show up to school, and made up all kinds of fantasy fiction about what the hell happened that day, crying tattoo tears and all kinds of nonsense. Meanwhile, he threw out her backpack and did all kinds of things so that no one in her family could ever enjoy her company again. This guy deserves what he's getting right now, just in my opinion. He just does. He did a lot. He lied a lot that makes him look guilty. They have him on video throwing away her backpack. They have him on video lying. They have him, his computer had so many images, they just had to pick the 60 most egregious. It's not there was only 60 images, which 60 is enough. There were thousands of images, but because they didn't want to overload the jury that they knew would have to see these images, they picked 60 images to depict the totality of the collection, just to give you an idea of how disgusting it was. Thousands, like 18. If the number's 18,000, it's 18. I mean, he had thousands. He was a collector, specifically of Madeline, but other children as well. Okay. A mess.
Mr. Johnson, would you be willing to make the presentation from the state? Thank you. Ms. Smith?
May I approach the court for defense exhibit one?
Of course.
So starting first with podcast, Judge, we have podcast showing Mr. Sterns. Defense did a screen recording as to essentially the number of shows and episodes, it's without sound, that are pertaining to this case. And on the next slide, it also shows essentially another screen recording of whether it be shows specifically, and then as well as specific podcast episodes that relate to this case, specifically in searching Stephan Sterns' name. Next, we have Madeline Soto, same thing, Judge, showing top results of podcasts that reference her. These podcasts
So they're screen recording the screen recordings. Okay.
are, as the court knows, podcasts can be from anywhere, but these are some local, international, out of state, various media and networks and outlets. And again, showing top results, specific shows that are doing episodes, as well as specific episodes relating to the case. Next is YouTube. Defense did a couple screen grabs of just searching of the name in terms of what comes up, various news articles, various.
This same thing, there was a lot of publicity surrounding Sarah Boone too. This particular prosecutor, Mr. J, is not going to be overly sympathetic to that at all. And also with Florida's laws, they are a state that is open as far as information and the public's right to know. I don't think that this is going to go very far.
News articles that have been turned into videos and clips of varying length, varying views. There are, including the interrogation of Mr. Sterns and the clips that relate to those. There's even, and I don't know if the YouTube will open in the courthouse or not, but.
Well, let me just say this other thing too. When I tell you the FOIA from Kissimmee Police Department and the FOIA from Osceola Sheriff's Department, and just the amount of information that I've gotten, I know other channels have received a ton. Okay. It's, if they felt a certain type of way, they should have created a block to, and she said, oh, well, it's almost all of the discovery. It's a lot of information. It's all of the police reports, the incident reports, the body cam videos, them interviewing people in the neighborhood, them talking to kids who were like, oh yeah, I know Madeline, she's in my class. I saw her last week on her bicycle, but I haven't seen her. She hasn't been back to school. Like, sad. It's sad because you know what happened to Madeline, but the kids in the neighborhood, the kids were on their bicycles riding around looking for Madeline. It's awful. It's awful.
But True Crime Beat, I even did videos pertaining to this very hearing and defense's request to close the pretrial proceedings in the case. The media may or may not let them play. And not that it needs to be played, but just for the court to see that the media has filed responses and YouTube videos in response to our very request to close the courtroom. In that same podcast or YouTube platform, True Crime Beat has an entire playlist that is related to this case with, at the time of the screen grab, over, I believe it's 443 videos at the time that the screen grab was created, which the date and time are in the corner. Additionally, more YouTube links in this case. True Crime with Strategic Eyes is another one of the popular YouTubers who has been blogging about the case and who additionally also has a playlist specifically pertaining to this case. Has already provided videos and done videos dissecting some of the defense's motions to suppress that were filed in this case. Gray Hughes Investigates, another popular YouTube platform, again with a playlist that pertains to this case. Turning to Reddit, this is where a lot of the discovery can be easily accessible. Defense does not have a Reddit account, is not logged in, as can be seen from the upper right-hand corner. This is just a true public search and what is accessible to the public, even without providing any type of identifiable information to request access. And searching Madeline Soto's name, these are the various Reddit groups or Reddit forums that exist in the case. And looking at the one titled, I guess, hashtag or / Madeline Soto, you can see they have a resource where you can literally click a link and get access to the case files in this case. And the screen grab on the bottom right, case files for missing and endangered, is what happens when you click that hyperlink and go in there. Next, we have Maddie Soto evidence, which is literally just that, a Reddit, though in discussing the case as well, even as the time of the screen grab of March 11 had been discussed 2 days prior, but has an entire Google Drive with the entire court docket, and includes master list of all the various files in the case. Again, public access that anyone and everyone can click and access. Madeline Soto evidence, again, pertains to all of the court documents in terms of this case and the accessibility of such. And looking at Jen Soto's, when you search Jen Soto's name on Reddit, some of the groups overlap. However, there is Reddit forums that keeps track literally of the upcoming court dates, including the various court hearing and date that we're here for before, as can be shown by the bottom right screen grab. As I was saying, in searching Jennifer Soto's name, those are the Reddit forums that come up under her name. They cross-reference with Madeline as well. In searching Mr. Sterns' name, again, some of them cross-reference and are similar, are the same forms that come up when searching Madeline or Jennifer, but those are additional forms for that. In searching X, formerly Twitter, these are just various screen grabs showing from initially back a year ago when the case happened, even up until present day, and showing various news outlets that show communications involved in the case, including, as can be seen from the right screen grab, we have Miami in Spanish as early as this year, Orange County, their own Twitter page, providing updates at the time they were doing it, Fox Orlando, again, back in 2024, even as recently as a month ago, talking again about these various hearings that we're here for. We have Puerto Rico, Orlando, New York, English, Spanish channels from 2024, as well as current day 2025. TikTok screen grabs, you can see the next to the heart are essentially the number of likes that a video has gotten. So we have various likes from mere thousands up into the tens of thousands that show from various platforms of varying sizes what they found, searching hashtags related to Madeline or Stephan Sterns. Same thing, more, we have up to 46.2K as low as 380. And then Facebook, this is hard to see, but the groups on the left are all Facebook groups that specifically relate to Madeline Soto, and the groups on the right, the 3 groups specifically relate to Stephan Sterns. The groups are varying sizes, various names relating to Madeline, finding her, missing, thoughts and different topics of that nature. And then finally is Google searches, if the court wished to. Essentially, when you search their names, you can go to the various Google listings and all the articles that pertain to each of them. And then in some of the news articles, I just grabbed a couple. Obviously, we have various different news articles, but Court TV is a popular news station who has an entire page literally related to Stephan Sterns and various proceedings, including as recently as this month, articles being posted as recently as last week, linking to others. And then Paula Neal Mooney has as well. In the podcasting area and some of the Google search, you'll see like Nancy Grace TV and various other media outlets. So that, coupled with the articles that defense was providing, show the various media coverage from local, meaning Central Florida, local within the state of Florida, outside the state, and locations and places that, honestly, I can't tell you exactly where they are, but for it's saying New York, Puerto Rico, or things like that from the news because of the pervasive nature of media and the ability to be anywhere at any time, not necessarily having to give locations as to that. So in terms of presentation of the media information, that's what defense had in terms of the PowerPoint, and otherwise we'll just have an argument.
Thank you. The defense has certainly established that there is a tremendous amount of media and social media interest in the allegations in Mr. Sterns' 2 cases before the court. The Miami Herald case gives the court some guidance as to what factors need to be considered in making a determination before a court may close its proceedings and operate in secret outside of the purview of the public and the media. There is a presumption that all pretrial hearings should be open ones. That is a fundamental tenet of the criminal justice system in the United States. Defense, I'd like you to curtail your argument to the considerations that closure is necessary to prevent serious and imminent threat to the administration of justice, that no alternatives exist other than a change of venue that would protect the defendant's right to a fair trial, and that a closure would be effective in protecting the rights of the accused. Obviously, the court must balance the due process right of the accused with unrestricted access to all judicial proceedings. Whenever you're ready.
I provided case law, I believe. Is that, do you have a judge?
I've got a lot of case law.
I handed a packet that had 2 statutes and 3 cases, Rule 2.450, Rule 2.451, and then the 3 cases being Gannett Co. versus the Pascal, which is a U.S. Supreme Court case, 99 Supreme Court 2898 from 1979, the Miami Herald versus Lewis case, which is a Florida Supreme Court case, 426 Southern 2nd, 1 from 1982, and then Miami Herald Media Company versus State, which is a 3rd DCA case here in Florida, 218 Southern 3rd, 406 from 2017. So looking at those 3 prongs, which are established by the Miami Herald case, the defense would argue that the closure is necessary in this case to prevent serious and imminent threat to the administration of justice, because looking at rules 2.450 and 2.451 gives the court the ability to control the conduct of the proceedings before the court, ensuring decorum, prevent distractions, and ensuring the fair administration of justice. So as such, this falls within the court's discretion. The media in their response talks about openness and transparency as being needed to produce a disinclination to testify falsely, when in reality it creates nothing more than an air performance, as if the courtroom is nothing more than a stage. Yes, people have a right to know about what happens in court and the analysis that comes along with that from internet detectives and analyzers, many of whom aren't even in the state or potentially even looking at the laws that apply specifically within the state of Florida, or the case of this jurisdiction is an entirely different story. So essentially this prong looks at why, which goes to the jury instructions ultimately that, at trial, the court will be looking to. Potential jurors are exposed to facts that they aren't supposed to be exposed through the publicizing of the case. Defense isn't requesting a full closure of the courtroom. We're specifically requesting closure as to the pretrial proceedings. So the 3 motions to suppress that defense has filed and will be requesting hearing time on are what we're kind of looking to in terms of that closure. And so in looking at the Gannett case, which is the U.S. Supreme Court case, they talk about, and in that case, they found that the court's decision to close the courtroom was a balancing act, as the court indicated. Nowhere with that case specifically actually dealt with the motion to suppress and the publicity concerning the pretrial suppression hearings in that case, similar to what defense would argue in this case, poses special risk of unfairness, because the whole entire purpose of a motion to suppress is to screen out evidence that was potentially illegally obtained or is otherwise unreliable in some manner or some fact that should not otherwise be known to the jury. And so while the court should allow publicity in general instances during the pretrial hearings, like the motion to suppress, that can further influence the public's opinions against Mr. Stern and allow the public to, as well as the potential jury, to have inculpatory information that would otherwise be admissible in the actual trial. And so the danger of the publicity in allowing the admissibility or the publicization of that pretrial suppression hearing makes it difficult to measure what.
You know what? I agree with it's right. It's hilarious that the most egregious offenders are always worried about. It's crazy. It's like they want to do what they want to do in the dark. They don't want anyone talking about it. And then they want the most privacy. And but then they'll use the media when it's appropriate, right? Him and Jennifer went on interviews. They did interviews when he was sitting up there pretending that he had dropped Madeline off at school. Meanwhile, we all know that that was not the case. I wish somebody would bring that up. Mr. J, I have not seen this, like I told you guys, but Mr. J might say, you know what? It's interesting that you don't want the media, but when we'll see how snarky he gets with it. But when you sat up there and did interviews knowing good and well that you dropped that little girl's computer and backpack in a trash can, and then you sat up there and did multiple interviews, now all of a sudden you're concerned about the media. But you were okay with using the media when you were trying to manipulate getting away with it. Now that you're sitting on trial, now you don't want the media. Okay? How about that?
What, if any, effects that would have on the actual proceedings. And the Sixth Amendment, which is codified through the 14th Amendment, talks about fairness and the openness of trial itself. Nowhere in the Constitution or common law does it specifically reference or refer to the access to pretrial hearing. So the access to trial, which defense isn't requesting trial be closed, we're specifically requesting pretrial hearings, isn't statutorily, constitutionally precluded. We're asking for pretrial. That's not a right that is guaranteed by the rules, by the courts, and that's found in the Gannett case, as well as further found in the Miami Herald Company versus State case, deals with the pretrial publicity. The second prong, Judge, that the court looks to is that no alternatives are available other than change of venue, which would protect Mr. Sterns' right to a fair trial. And looking at that factor, this is pre-trial, i.e. before trial. So the entire purpose of this would be in allowing for the closure of the courtrooms during those pre-trial proceedings. Hopefully and potentially it will prevent the need to change the venue in this case come actual trial, because of being able to limit and curtail the information that the media has access to, and that there are no other alternatives. As the court saw from the PowerPoint, from the various articles that I provided, the media is, and likely will continue to dissect any and every aspect of this case, from the public records request through discovery that was provided via the state, through the public records forum, through any motion and every motion that defense files in this case. And so defense would argue there are no alternative measures that would, other than changing venue, that would preclude or allow for Mr. Sterns to have a fair trial. And finally, closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Again, defense is requesting only the closure of pretrial proceedings, such as motions to suppress in this case, not the closure of the court for the actual trial. And so we're asking for a limited nature of the proceedings being closed or foreclosed. In the cases that defense cited, some dealt with a motion to suppress, one dealt with specifically an Arthur hearing, and one even had a motion to suppress where the hearing itself was closed. However, after a certain amount of time, the access to the transcript was allowed to be gained by the media or those interested parties. So the court was able to, in crafting their order, limit both the time and the duration, the nature, as well as allowed a remedy to allow them to have access at a later point in time. I believe that was the Miami Herald versus State case, in which they dealt with that. So defense would argue that essentially, while pretrial publicity and the fact that there is pretrial publicity in this case, a lot of these cases that formed the basis of allowing for the closure of the courtroom was pre a lot of the forms of media that we have now. TikTok, Instagram, Facebook, Reddit, podcasts. A lot of those mediums didn't exist back in the 70s and the 80s when these cases were decided, allowing for the court to allow restriction and closure. The pervasive nature of the internet itself and the exposure makes it to where the pretrial publicity, both the emotional aspect of it, should allow for this court to grant defense's motion to allow for the pretrial closure of certain proceedings subject to whatever limitations the court should impose, such as if the court were to grant closure for motion to suppress, for example, and allow at a certain period of time the allowance or the dissemination of that information, or if the court were to say motion to suppress are not allowed, no access to it, they hear it at trial. So defense would argue that defense meets the three prongs by the preponderance of the evidence, which is the standard that defense had to meet the prongs by as to each of the factors, and the court should grant defense's motion to close the pretrial proceedings.
Thank you, Mr. Smith. State?
Judge, it's the state's position that they haven't shown anything by a preponderance of the evidence. There is massive worldwide coverage of news these days, but it's very spread out and only deep in very certain puddles. A basement in Sheffield, England may have hit the Reddit, may have hit the YouTube, may have hit all those different sources of news, but they have not shown any nexus to the potential jurors in Osceola County, Florida, and all of the data that they presented to the court. They didn't even show you how many views any of those YouTube videos got, how many upvotes or downvotes any of those Reddit posts got. They haven't shown you how many people viewed any of those news stories, much less how many people in Osceola County jury, Osceola County, Florida, they're eligible to serve on the jury, viewed any of those things. There hasn't been a study conducted by a UCF student, for example, to go out and poll jurors and provide the court with data about the effectiveness of the media coverage in this case in conveying its message. The unfortunate truth that I have found, because as this court knows, I ask every potential jury panel, do you even follow the news? Do you get a newspaper? Do you watch the local news? And it's stunningly small how many people actually follow the news. And in a high profile case that I just did in October up in Orlando, had a whole subreddit and all the YouTube and the sleuths and all the stuff that they presented you. We put 50 jury panels Monday morning, 50 jury on the panel Monday afternoon, Tuesday morning, Tuesday afternoon, and maybe 2, 3, or 5 in each panel of 50 had even heard of the case. And perhaps 2 got excused for cause because of their exposure to the case. I don't say that as evidence. I say that as an anecdotal link to, well, where's the link to Osceola County? The YouTube is not just exclusive to Osceola County. WESH isn't exclusive to Osceola County. Reddit certainly is not exclusive to Osceola County. Where's the data about the effectiveness of the message in Osceola County? And it's just not there. And I would submit that without it being there, there's no data for the court to decide that there's a preponderance of evidence shown that this media has been effective in convincing anybody in this county about anything.
Thank you, State.
Period.
I'm going to invite you to the podium.
Yes, that is the same prosecutor from the Sarah Boone trial. When I saw him earlier, I was like, oh my God, it's Mr. J. So this is the 9th District of Florida, and Mr. J works for the 9th District, and that is the 9th District is comprised of Osceola and Orange County. So there you go.
Mr. Minchin, I've reviewed Miami Herald. I'm not convinced that there's an automatic entitlement to intervention. I think that's still requires leave of court, but I do want to give you an opportunity to proffer the argument that you are intending to make. I will, in a written order, indicate whether the court considered that argument in making its final determination, and I'm going to give the defense an opportunity to respond to both the state and any argument made.
Thank you, Your Honor.
Whenever you're ready.
I was able to locate some authority for that proposition, however, even within the Lewis case itself. If you look on page number 7, that's head note 6, and then some other case law as well. Quote, the news media has been the public surrogate on the issue of courtroom closure. Therefore, the news media, quote, must be given an opportunity to be heard on the question of closure prior to the court's decision. Also, Chavez versus State says the same thing, notice and opportunity to be heard prior to closure. Pinnock versus State also, notice and opportunity to be heard. Those are second DCA cases as well. So that is the authority that I'm moving under the Supreme Court's decision that notice and opportunity must be given.
Thank you. When you're ready, argument.
Yes, sir. From the onset, I just wanted to point out that this is, in fact, an evidentiary hearing, and the only evidence that has really been proffered to this point has been that there has been a lot of media coverage of these proceedings, and that's typically the way it works in these cases. Typically, there has been a lot of media coverage, but that has never been sufficient to justify closure. Lewis says, quote, those seeking closure must carry their burden to demonstrate a strict and inescapable necessity of closure, strict and inescapable necessity. And that is an extremely high standard, and that's that phrase, strict and inescapable necessity of closure, that has been used in the case law since then. It is an exceptionally high standard because there is a strong public policy in favor of openness and transparency in the proceedings. Some of those reasons are that it enhances legitimacy, credibility, public trust in the judiciary, protecting the accused rights, keeping judges, prosecutors, and witnesses honest. There's a lengthy quote, I'll summarize it from the Lewis case from the Supreme Court that says, public access to courts, this is quoting, is an important part of the criminal justice system as it promotes the free discussion of governmental affairs by imparting a more complete understanding to the public of the judicial system. Such access gives the assurance that the proceedings were conducted fairly to all concerned. And aside from any beneficial consequences which flow from having open courts, the people have a right to know what is going on. As the Supreme Court has noted repeatedly, the trial is a public event and what transpires in the courtroom is public property. Public access also serves as a check on corrupt practices by exposing the judicial process to public scrutiny and protects the rights of the accused pursuant to a fair trial. Finally, because participating lawyers, witnesses, and judges know that their conduct will be subject to public scrutiny, it is fair to conclude that they'll be more conscientious in the performance of their roles, summarizing most of the public policy arguments that we have on that. So the Lewis, you know the three factors, elements rather, they're not factors, they're elements that the defense must prove evidentiarily for it to show strict and inescapable necessity of closure. I'll jump straight to the first element, that is, closure of the proceeding is necessary to prevent a serious and imminent threat to the administration of justice. And there are a couple of arguments that the defense has presented on that point. The first is that inadmissible evidence may arise in the anticipated hearings. But the case law is abundantly clear that whether or not inadmissible evidence may arise in a hearing is wholly irrelevant to the calculus pursuant to Lewis. As the State versus Lugo said, quote, the need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. That's cited in the materials that we provided to your honor. State versus Houston said, quote, the inadmissibility of evidence has no bearing on whether evidence is or is not public record. And in fact, if anything, as Lewis said, whether or not evidence is admissible, in fact, provides a heightened importance of the right of openness. This is what the Supreme Court said in regards to suppression hearings regarding the admissibility of evidence. Quote, although they may prove to be unfounded, these are of importance to the public as well as to the defendants. The searches and interrogations that such hearings evaluate do not take place in the public. The suppression hearing is the only opportunity that the public has to learn about police and prosecutorial conduct. It is important that a decision of the trial judge on a motion to suppress be made on the basis of evidence and argument offered in open court, so that all who care to see or read about it may evaluate for themselves the propriety of the exclusion. So if anything, hearings on admissibility of evidence mitigates toward openness, not against openness pursuant to Lewis. The second argument that the defense has made is that there has been and likely will be publicity.
A little bit for the assistance of Madam Court.
Thank you. I appreciate it.
Yeah.
I want to be respectful of everybody's time. So there indeed has been a lot of pretrial publicity, but that has never been a sufficient justification for closure.
You know what? I was getting ready to check to see if I had the speed on not normal, okay? Because I was like, sir can talk. Okay, Sir really talks fast, but I get it. He doesn't have a lot of time, but he really, my God.
Closure for several reasons. First, closure based on alleged negative pretrial publicity is essentially impossible in counties of this size. I point you to the case law we cited on that. There are hundreds of thousands of people that are living in this county, and the case law is pretty clear on that point. Second, the defendant assumes that the coverage is prejudicial, which that is something that they must prove, and they have not proven that, just that there's been a lot of it. And third, pretrial publicity is not inherently detrimental to a defendant's Sixth Amendment rights. As the Supreme Court about it and who does not have some impression or opinion as to the respect of its merits. A presumption of prejudice is an extreme case, unquote. That's the Skilling case. This quote, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, unquote. So all that's been presented as far as just evidence of pervasive, but that has never been enough for those reasons. As to the second element of the test, no alternatives other than a change of venue would protect the defendant's rights to a fair trial. And there has been no evidence presented on this point. The Lewis court presents multiple alternative options that could be available. There was some argument made, but again, this is an evidentiary hearing. Argument of counsel is not sufficient. There could be a continuance, according to Lewis, voir dire, peremptory challenges, admonition of the jury, sequestration. All of these alternatives are talked about in Lewis. These were not even discussed, much less evidentiarily examined, and there's no evidence provided for them. So protecting the rights of the accused while being broader than necessary, being broader than necessary to accomplish its purpose. Under the case law, it's referred to as the narrow tailoring test. And we really can't meaningfully evaluate this because the wholesale closure of all these proceedings is about as narrowly tailored as possible. Rather than like a narrowly tailored suit, this is more like it's like a bolt of cloth sitting on the tailor's desk, entirely not narrowly tailored whatsoever. We can't really even meaningfully engage with this element because there's been no evidence presented on it. So also just to frame this in context, in summary, in closure too, this is not an unprecedented situation. Unfortunately, our state has seen its fair amount of very highly publicized criminal matters. Some of them are mentioned in our papers. Eileen Wuornos, Ted Bundy, Danny Rowland, Casey Anthony, George Zimmerman, Nicholas Cruz, many of whom, in fact, did seek closure under the Lewis test and they tried and failed because the strict and inescapable necessity of closure pursuant to Lewis and providing strong evidence to overcome and satisfy all those elements is an extremely difficult standard that is very rarely met. So because there has not been evidence to sufficiently justify closure as to all three of those elements, the media interveners ask you to deny the defense motion. Thank you, Mr. Lynn.
Okay, he made his argument. Okay. I mean, once he slowed down a little bit, I think he made a very good argument. What do you guys think in the comments? What do you guys think in the chat? If you're coming through later in the comments, tell me what you think.
Ms. Smith, any additional rebuttal pursuant to the state's argument or potentially Mr. Minchin's intervening argument?
Yes, Judge. In both parties, they talk about empirical data. However, if you look at the Miami Herald versus State case, the third DCA case, it specifically says that no case, the Lewis case, nor does any Florida case suggest that a trial court must consider expert testimony or empirical data. So while they said that has not been presented, that's not necessary in order for the court to rule that closure of a pretrial hearing is necessary to prevent imminent harm. The media interveners talked about, we're assuming that the coverage is negative. Judge, if you look at the articles that were introduced into evidence, the title of the articles in the court re-reviews, the PowerPoint, the heading and the titles of the articles, the podcasts, all of that, it implies or is negative in nature. None of it is saying wrongfully accused or anything of that nature in those titles. The media interveners talked about this being a high standard, and the preponderance standard is one of the lowest standards in a criminal courtroom or in a criminal case. It's just more likely than not, so essentially a 51%. So the defense would argue that by preponderance, defense has shown each of the prongs established. There is no need for empirical data. Some of the other cases they talked about, I believe in those cases, they were seeking complete closure of the media for all aspects of the proceeding. Again, defense is limiting this to specifically the pretrial proceedings in this case, where different evidentiary items could be found. The Miami Herald case, which the media interveners cite to and talk about a lot, the Florida Supreme Court case, the court did close the courtroom and that was upheld. All the cases that defense provided, the U.S. Supreme Court case, the Florida Supreme Court case, and that third DCA case, all are cases in which it was upheld that the closures that the trial court in those cases did was sufficient and was practical in light of the evidence and the cases that are presented. So defense would argue that based off the evidence and testimony that's been presented, that we have established by preponderance each of the factors or each of the prongs needed to satisfy the court that closure is necessary to prevent that serious and imminent threat, that there are no alternatives necessary or available outside of change of venue, and that the closure itself would be effective in protecting the rights of Mr. Sterns without being broader than necessary to accomplish the purpose. So we've asked the court for that.
Thank you, Ms. Smith. All right, the Lewis case requires that the court shall make findings of fact and conclusions of law so that any reviewing court have the benefit of the reasoning in either granting or denying closure. I intend to do that in writing. Ms. Smith, let me ask you, as far as timing of the court's order, are any of these pretrial proceedings currently set for a hearing before the court?
No, Judge, we were going to request hearing time this week, but wanted to give the court that benefit if you wanted to tell us to ask for after a specific date so that we didn't have to go back and reschedule anything.
All right. I anticipate I'll have an order out well in advance of 10 business days. State, anything further?
No, Your Honor, thank you.
Defense?
No, Judge.
Thank you. That will conclude our hearing.
How many people do they have on him? 1, 2, 3.
I thought I gave it back.
Yeah.
What do I have?
B, C, and D.
Okay, so the person that was talking fast, the one that someone stated sounded like an auctioneer, he was representing the media. He was here for us, social media people. He's here for the traditional news media. Filed this motion to make sure that they were on record because the defense is trying to have the media kicked out during the pretrial phase. And the state pretty much just said that there's no proof that with the evidence that Stephan Sterns' attorney, I don't know her name, I'm looking on the file now, but I don't see it. There's no evidence to support that just because there is media attention doesn't mean that the potential jurors will ever see. They will see that, they will be influenced by that, they will be selected and even sit. So it's not a foregone conclusion that just because someone did a podcast that person is going to sit in judgment. Maybe it's Melissa Vickers, will sit in judgment of Mr. Sterns' case. Okay. So I suspect, I don't know, Florida, they're not likely to kick the media out. I just don't see it. I don't see it happening. I just don't. It's possible, but I don't see it happening. Let me see if I did this correctly. Okay. Okay, I'm gonna shut this one down. And I'm gonna come back. I'm gonna set up another one. I'll be back in like 10 minutes. Okay, just give me like 10, maybe, yeah, like 10, 15 minutes. I'm gonna set up another live though, and then I'll be back with some other stuff to talk about. Okay. And then you guys can tell me what you guys are eating for lunch. All right. All right, let me take this one down and I'm going to put up another live and I'll hit the go live in a little bit. I just want to try to eat something first. Okay. But I'll put up the live now. So if you guys want a place to talk and congregate, it will be available in just a minute or two. Okay. All right. I'll see you guys. Bye, guys. Thanks for joining me for this. If I don't see you, then I'll see you back later. But okay.